Hello friends, Namaskaram. How are you? Today I am going to discuss an important judgment of Honorable Allahabad High Court. The judgment is in favor of accused, wherein the benefit of anticipatory bail is granted to him. Do you know, in that case, the concerned accused persons had been charged in dealing with government land. Do you know, in that case, there is an allegation on the accused or applicant that he has purchased the government land. Do you know he has caused the huge loss to the government, and despite of that he got the anticipatory bail. And apart from that, there is a gang of 7 or more than 7 persons who are allegedly indulged in the alleged crime wherein the government land had been sold or purchased by the concerned accused persons by having a criminal conspiracy or hatching a criminal conspiracy. Both are same. And apart from that, the proceeding in nature of proclamation. As we know that section 82 and section 83 of CrPC deal with the same. It says that if the concerned accused is absconded and there is no possibility of getting his appearance in the court of law, in that scenario, the court may issue the proclamation and may specify the date and time, and even though he is not appearing, the court may forfeit the property to assure the appearance of the accused so that the proceeding could be conducted. In the present case at hand, the concerned Honorable Allahabad High Court had inclined the remedy in favor of the concerned accused. Despite of having serious offence, despite of having the more complication in the legal proceeding. But all these things are possible when we are having an extensive research in that subject, so that if we are having the same problem, we could easily deal with the same and could get the remedy as per the available resources. Okay, now got the point? It is easier. First of all, you are required to note down the judgment name. Judgment name is Ankur versus State of UP. Anticipatory bail application number 2090/24, and judgment has been pronounced on 21st of October 2024. Got the point? Now it is easier. And judgment is available on indianqanun.org, from where you could get the judgment copy. In that case, the accused has applied for the anticipatory bail, but Sessions Court rejected the application on the ground that the offence is serious and that's why he cannot avail the benefit of anticipatory bail. And as we know that if the offence is serious, and gravity of offence is one of the most important criteria to decide the factum of anticipatory bail, whether it's to be inclined or declined. Got the point now? And apart from that, when the accused had moved before the Honorable Allahabad High Court, he specified the things in the easy manner, because the accused is very much conversant with the fact that he cannot avail the benefit of anticipatory bail because the facts are too much complicated. The scenarios are compromised as far as legal position is concerned. So he tried to convince the Honorable Court in the following manner. First of all, he submitted that it is a fact on record that FIR has been registered. Okay, now easier point. Point number 2, FIR has been registered as per section 420, section 467, section 468, section 471, section 120B of IPC. Easier point. Number 3, in which there are 7 persons who are added as an accused. Number 4, Mr. J, who is one of the prime accused in that crime, is alleged with allegation that he had sold the government land to Mr. A. Okay, but he got the anticipatory bail. He submitted that Mr. R, who had sold the land to me by the way of agreement, inter alia got the anticipatory bail. Number 6, there is no sealed deed, rather than there is a registered agreement, and the concerned stamp duty has been paid. The consideration which was decided had been paid in part, and there are resources regarding the same. There is nothing regarding any concealment or material fabrications on the record. And apart from that, the possession has not been handed over to him, and when the alleged fraud had come into his kind knowledge, he applied for cancellation of alleged agreement and for recovery of the amount. So he is victim of the fraud, and the 2 accused who got the anticipatory bail from the Honorable Court, and that's why on the point of rule of privity, he is eligible to get the benefit of anticipatory bail. These are the common points, common argument done by the concerned accused in the court of law. Concerned state opposed the bail application on the 2 grounds. But 1, the offence is serious and the remedy is not the matter of right. It could be availed in exceptional circumstances. The accused is totally failed to narrate the circumstances in which he is eligible to get the benefit of anticipatory bail. The concerned state relied on judgment of State of MP versus Pradeep Sharma. Judgment had been pronounced in the year of 2014, and apart from that, he has relied on judgment of Prem Shankar Prasad versus State of Bihar. Judgment has been pronounced in the year of 2022. In both the judgment, it has been specified that the benefit of anticipatory bail can be availed in exceptional circumstances. And apart from that, the proceeding in nature of proclamation. which are totally governed by section 82 of CrPC had been initiated against the accused. So when the proceedings has been initiated against the accused in nature of proclamation, he could not avail the benefit of anticipatory bail, and regarding the same they relied on citation of Honorable Supreme Court titled as Lavish versus State of NCT that has been pronounced in the year of 2012, and apart from that they relied on judgment of Srikant versus State. The judgment has been pronounced in the year of 2024. So looking into the fact and circumstances, legal scenario, they requested the court to reject the bill. So the court is very much clear. The concerned accused is not eligible to get the bill, but court specified that if the remedy is not available under the law, in that scenario every grievances would be remediless. So we have to consider the impact of this judgment on the present case, and apart from that we have to cite and we have to consider the recent judgment regarding the availment of the remedy of anticipatory bail to the concerned accused, even though the proceeding in nature of proclamation is pending against the accused. Okay, so in that sequence the court has relied on the judgment of Sushila Aggarwal versus State of NCT. Judgment has been pronounced in the year of 2020. In that case the court specified that the benefit of anticipatory bail can be granted and no restrictive conditions can be imposed to make it fruitless. And apart from that, in Dharampal versus State of UP, judgment has been pronounced in the year of 2023, but by the Allahabad High Court. It has been specified that the benefit of anticipatory bail can be granted in the exceptional circumstances. So clear thing is that if the case is false, the benefit can be granted, but the court has to consider the fact and circumstances to check out whether a case is made out for anticipatory bail or not. In that case, the court specified that only two accused had been availed the benefit of bail remedy from this court. So on rule of parity, the concerned accused can get the bail remedy, and apart from that, the facts are compromised, so that we could easily conclude that he is falsely implicated and he is bona fide in his approach, because it is a right of a person to purchase the land and he is not aware about the nature of land, that it is a government land. So when this fact has come into his kind knowledge, he has applied for cancellation of agreement and for recovery of the money, which is totally permissible as per section 20 of the Specific Relief Act 1963. And apart from that, position is not with the applicant and he has paid the consideration and he has also paid the stamp duty. So everything is clear, indicating his bona fide. So in that scenario, the benefit of anticipatory bail can be granted even though there is a proclamation warrant against the concerned accused, because there is nothing on the record to show that he has absconded, because he has totally failed to avail the bail remedy. In that scenario, it could not be assumed that he has absconded or he is having any deliberate intention. He has come with clean hand before the court. He has specified each and everything. All the facts submitted by him are uncontroverted. So looking into the fact and circumstances, the court has granted the concerned accused the benefit of bail. So by the present case, we could conclude the following 5 things. Whenever there is a case against you and the case is very much serious, the offense is heinous and you want to avail the bail remedy, just read the FIR. Make out the point, make out the brief, submit the reply and ask the concerned IO to drop the proceeding. Number 2, in addition to anticipatory bail, we are required or supposed to go for questioning as well. Number 3, while specifying the case for anticipatory bail, specify that why case is false. Number 4, try to chalk out the judgment in which the anticipatory bail has been granted to the concerned accused on the same fact and circumstances in which you are indulged regarding the present case. Number 5, do not be in hurry and do not be in the anxiety while moving for the anticipatory bail or for the questioning. Just point out the legal position. If the offence is punishable up to 7 years and benefit of section 35 subclause 3 BNSS is not given to you, you may avail this point also. So these are the important points which are required to be borne by you in your mind, so that you could avail the bail remedy and could easily contest your case on the merits even though there is a proclamation warrant against you. So things might be against you, but if you are serious and you know how to contest, then you could easily avail the bail remedy in the court of law. So I think that I am totally able to clarify you on the subject. So see you in the next video. Till then, Jai Hind, Jai Bharat.